So everybody's talking about Roe versus Wade. I've been in trial for the last 2 weeks, so I hadn't had an opportunity to address this, but obviously the case is a disappointment when from the standpoint of your right to privacy. It's important that when you look at the decision that was made in Roe versus Wade, that you decide whether or not privacy is a big issue for you, because at the end of the day, the court is basically saying that privacy is not that big of a deal. And so privacy does include, as Judge Thomas referenced in his dissent, a dissent again is not the majority opinion, but he is part of the majority that authored basically an extrapolation of what the other majority justices said. And he basically said, look, when you make this argument, or you take this argument to its logical end, and you say that privacy doesn't include abortion, the right to make decisions on your body, then you're also saying that privacy also potentially would negate your fundamental right to marry somebody of the same sex, to marry the person of your choice, all the way to things about contraception. He actually cited the cases, Judge Thomas cited the cases that give those rights. The important thing to understand is the genesis of the abortion right, and the genesis of the contraception right, and the right to marry who you choose, all come from the right to privacy. The right to privacy is not in the Constitution. So this argument that Judge Alito makes in the majority opinion that the right to privacy is not in the Constitution, or the right to abortion is not in the Constitution, is actually the same argument that can be made for the right to privacy, because the right to privacy is also not in the Constitution. To suggest that the court doesn't have to follow 50 years of precedent is also, respectfully, I would suggest, not in line with the court's decision, because as many people have pointed out, the ability of the Supreme Court to actually review cases is actually not in the Constitution either. The ability of the Supreme Court to review cases is actually part of the case law that they're supposed to be observing as part of precedent. In other words, the reason everybody's so up in arms about Roe versus Wade is that everybody had agreed, even the justices that voted against it, that it was settled law. Settled law means it's not written in the Constitution, but it's been adopted by the Supreme Court as settled. The other thing that's settled law is the right of the Supreme Court to actually do legal analysis on cases. That's not in the Constitution either. But they decided in this case to basically uproot the right to have an abortion by saying you don't really have a right to privacy that gives you the right to an abortion. So it's really important. I know this is a controversial subject. I know everybody wants to get politics involved, but I think it's important for everybody to understand that before you start declaring a position politically, you should think about the fact that the right to privacy is at the root of this decision. And if the right to privacy is revoked for abortion rights, or the right to choose, as some would say, then you also have to worry about the basis of the right to privacy for a multitude of other things that the Supreme Court has said are also fundamental rights. It's important for you, obviously, because of this decision. The majority of the court has said basically this is now a legislative function. That means that every state race for House, for Senate, every federal race for House and Senate is now the place where you have to fight these battles on the right to privacy. The right to choose, the right to marry somebody of your choosing, the right to use contraception, all of those things, in order for them to be fully protected now that the right to privacy is suspect, it has to be the subject of a law that is passed either by the state or on the federal level. So, long and short is this: if you don't want a patchwork of this state says yes, you can use birth control, this state says no, you can't, or this state says your marriage to the person of the same sex is okay in Florida, but it's not okay in Alabama, and if you're driving across country and you die in a car wreck in Alabama, or is Alabama going to recognize the fact that you're married even though Florida did or Georgia did? If you want a patchwork of different laws in regards to privacy, then every state's going to be left to their own ambitions. If you want a country that is united under the same thinking in regards to the right to privacy, right, then we need a federal statute on all of these issues so that none of this is up for debate anymore. We all assumed it wasn't, except for 30% of the population, or maybe even less than that, that was still fighting for the right to take away women's ability to choose. But aside from those folks, even those folks agreed in large part on the right to choose on contraception and the right to for same-sex couples to get married. So this is more of a PSA than it is a legal discussion. The legal part of this, I felt important to point out, was the fact that all of this comes from the right to privacy. The right to privacy is not a constitutional right. The right to privacy was something that was interpreted by the Supreme Court to exist and to endure to every citizen of the country. And that has been called into question by this opinion. I urge you to read the text of the opinion. I urge you to read the concurring opinions and the dissenting opinions. I said earlier that Judge Thomas was a dissent. His actually was a concurring opinion because he agreed with the majority. He just felt like it should have gone further. And he basically said that logically, if you use the same reasoning that they used to make this decision in the Roe case, it logically extends to all these other rights because the right of privacy is the common thread. Good luck. Go vote. Make sure your voice is heard, no matter where you fall on the spectrum. Thank you.